Thank you. Dr. Hayes.
Thank you, Judge. I just drove through traffic, and I'm happy to be here on time. I was actually at an Aspen Institute conference in Eastern Maryland, and don't be alarmed, I wore a neck brace so that I suffered little physical damage in swinging from side to side to come here to the Federalist Society. At any rate, my name is Thomas Hazlett, and I'm a PowerPoint user. So with that introduction, Red Lion actually invited evidence on the issue of whether or not this Fairness Doctrine was a chilling effect. It's not a slam dunk. The question arises because, in fact, the Fairness Doctrine imposes obligations on speakers and members of the press. And it was quite clear to the Supreme Court that upheld the Fairness Doctrine regulation 8-0. I don't know if that's emphatic, because equally emphatic to the 8 that voted yes was the lone non-present member of the Supreme Court, William O. Douglas, who emphatically later noted he would have dissented. But the fact is that that opinion invites evidence saying that if, in fact, there had been evidence of a chilling effect, that the decision would likely have been different. And the Supreme Court drops a footnote into a speech, a public speech by Frank Stanton. And this was supposed to tell us something about Frank Stanton, of course, the president of CBS News. This was supposed to tell us something about whether or not there was a chilling effect. And the speech from the president of CBS News was that, in fact, the press will not be cowed. Now, unknown to the United States Supreme Court was that all through this period, CBS News executives, including Ed Paley, the chairman, and in fact Frank Stanton, the president of CBS News, were meeting in the White House with top executives of the United States government. In fact, in the Johnson administration, they actually discussed affiliation agreements with stations owned by the president's wife. And with the Nixon administration officials, they regularly discussed whether or not there was anything that the administration wanted to adjust in the coverage of news and public affairs. So Stanton's speech in public was chilled, and in fact directed towards the idea that there was nothing untoward going on so long as privately they could carry on this kind of symbiotic relationship. So that chilling effect ought to, in fact, be chilling, but we need not rely on it today, because now, with some deregulation, we in fact have very remarkable evidence from the marketplace that shows us what happens when we lift the constraint of the Fairness Doctrine. Do we get more? Do we get less of what the Federal Communications has identified as public interest programming? Well, because radio stations so neatly classify formats in a way that broadcast television does not, we're able to very easily go to the videotapes, as it were, and look at data from the post-deregulation radio market, which I did some years ago with a former student of mine, David Sosa, publishing it in the Journal of Legal Studies in 1997. I should say that between 1975 and 1975 and 1995, there was a very pronounced upward trend in the number of radio stations, particularly FM radio stations. And through pro-competition policies, there was, in fact, an encouragement to more competition in the marketplace. That, as background, simply opens the door to what happens with informational formats, news talk, the news talk, and what is called information and public interest programming in these formats, up through about 1987, when we had the Fairness Doctrine abolished by the Federal Communications Commission. You have somewhere around 7% of all AM radio formats devoted to information. And then it just takes off, and by 1995, just a few short years later, you're up to over 27% of all AM radio formats. I should note, quite interestingly, that there was an entirely new category a new format that was created in the wake of the abolition of the Fairness Doctrine called News Talk, and this became quite popular and some would say dominant in AM formats, but FM was not left behind either. In fact, if you're interested about FM, yes, in fact, the total informational formats on FM take off after the 1987 abolition of the Fairness Doctrine as well, and even religious, if you're interested in free speech and religious speech, then those formats do very, very well. And so, indeed, today as we stand here, we do have evidence of the chilling effect. It's not really in debate. Indeed, folks who say that we should have a fairness doctrine often pointedly say that they want to chill certain types of speech, that there's things that should not be on the airwaves. So the fact is that this is a widely seen bit of evidence. But there's a lot of other stuff out there that does not have to do directly with the Fairness Doctrine, and indeed the attack today on free speech will not be through a direct reenactment of the Fairness Doctrine. The equal time rule is already in place by statute since 1927. We've heard that in fact the codification the codification by Congress making the Fairness Doctrine statutory has been rejected, but in fact, I think that's a little generous, that indeed the public interest licensing law, by its nature, does give discretion to regulators to, in fact, award licenses with respect to content. And these rules that are now being, are still in place for localism and media ownership automatically raise the opportunity for First Amendment violations. In other words, arbitrary rules by regulators that discriminate on the basis of content and the speech that is conducted. And it's very interesting that there is intense opposition for a more libertarian rule. So there's been a challenge to you conservatives. I don't know if being on the panel I'm counted in your midst, but the fact is we should all get around more and see exactly who is criticizing, for example, the Kevin Martin FCC on its and the Bush administration in general for its very antithetical policies with respect to the First Amendment on licensing rules. And they had some opportunities to make great strides. They did not take them. In fact, they did go backwards on many occasions. That has been roundly criticized by libertarians and conservatives in many respects, despite the fact that, as I have written on many occasions, the conservatives were clearly on the wrong side of the Fairness Doctrine 22 years ago, and in fact largely opposed the abolition of the Fairness Doctrine. I'll just leave with this, that if we have a nice discussion about the public interest standard and how constitutional it is, we should at least understand that the idea that there is a finite number of radio licenses is a complete myth. There is no finite number. I challenge anybody on this panel to tell me what the number is. If it's finite, let's name it. There is no finite number of radio licenses. If you understand radio spectrum, if you understand what licenses are, if you understand property rights, you know that these can be divided and subdivided in all kinds of interests. They are in no respect different than any other sort of property right. And Ronald Coase did eventually get a Nobel Prize for writing this up 50 years ago, so the licensing fee goes to him. But the simple fact that there is no physical scarcity doctrine is in the imagination of Felix Frankfurter in that 1943 NBC opinion that somehow has managed to sort of stumble its way into the 21st century. And today, with the convergence of all media, the fact that my New York Times is delivered to me through a wireless connection on what are called physically scarce airwaves, therefore opening the door to regulation of the New York Times on the basis of the fact that it uses these so-called physically scarce airwaves, it ought to be even a little bit frightening to all of us, liberals included, who are quite content for the public interest doctrine that, but by the way, did not come from New Dealers. The public interest doctrine that is in the law today came directly from the National Association of Broadcasters in the 1920s. This, according to Senator C.C. Dill, Clarence Dill, a Democratic senator from the state of Washington, was a sponsor and author of the 1927 Radio Act. He makes this quite explicit in his book, Radio Law, written in 1936 after he left the United States Senate.